In this podcast, we talk about how promissory estoppel can be used. Can it be used as a sword, or can it only be used as a shield? If you're using promissory estoppel as a shield, then you're using it as a defense within an existing contractual relationship. As in, I didn't do what we originally agreed in the contract because I relied on your statement outside of the contract that I no longer had to do it. If you use it as a blunt sword, you're using it as a cause of action within an existing legal relationship, meaning you're suing somebody, you already have a contractual relationship with that person. If you use it as a sharp sword, it means you're using promissory estoppel as a cause of action to create a legal relationship, meaning you don't have a relationship with the person you're suing, and you are nonetheless suing them on the basis of promissory estoppel. Remember that promissory estoppel protects reliance and it prevents inequity, but it has an unsettled role based on principle and traditional principles versus progress. There are different articles that will say that promissory estoppel is a defense versus it's a blunt sword. And what we'll see is although there is this range of possibilities, using it as a sharp sword is generally not accepted, and it has been accepted only in a very narrow set of circumstances. So we'll get to that case. In this case, Cumin and Coomb, a husband gratuitously promised to pay £100 to the plaintiff on separation, his wife, and in reliance on the promise, the wife did not apply to the courts for maintenance. She refrained from applying. The defendant refused to make the payments, and she sued after 6 years and 3 months. Now, the annual income for the plaintiff is £700 to £800, whereas for the defendant, it is £650. And the issue here is promissory estoppel an independent cause of action? In trial, they relied on high trees, and they gave judgment for the plaintiff on the basis that the defendant had made an unequivocal promise which was intended to be acted on and which was in fact acted on. Now, recall that this is the test that was laid out by Denning in High Trees. And you see here that in the appeal, he retreats from that very broad test. Seeing that the principle never stands alone as giving a cause of action in itself, it can never do away with the necessity of consideration when that is an essential part of the cause of action. The doctrine of consideration is too firmly fixed to be overthrown by a side wind. Its ill effects have been largely mitigated of late, but it still remains a cardinal necessity of the formation of a contract, though not its modification or discharge. In Cumin and Coomb, the wife had given no consideration for the promise, but she sought to enforce the promise on the basis that it was binding under the doctrine of promissory estoppel. Now, the role of promissory estoppel is restricted to preventing parties from insisting upon their strict legal rights in situations where it would be unjust to allow these actions to enforce them. Here, Denning retreated from the breadth of High Trees. High Trees misleadingly suggested that promissory estoppel is an independent cause of action. Promissory estoppel merely enforces a gratuitous promise to suspend rights. But here, Denning said that the doctrine of promissory estoppel can only be used as a shield, not a sword. It cannot be used to create a new cause of action to enforce the promise itself. It can be used to affix the existing rights under a contract. In this case, promissory estoppel was inapplicable on the facts. The defendant's promise did not purport to vary existing contractual rights because there were no pre-existing contractual rights between the parties. And detrimental reliance is insufficient for consideration. The plaintiff's reliance did not suffice for the creation of a contract. There's an absence of a relationship of mutuality. So here, the doctrine of promissory estoppel was very much restricted to being used as a shield. meaning that if there's no relationship between the parties, legal relationship, the doctrine of promissory estoppel cannot be used to create a relationship. And just because someone detrimentally relies on a promise, if there is no existing legal relationship, that reliance does not suffice for the creation of a contract. So, promissory estoppel, you see Lord Denning refused to enforce a promise on the basis that no consideration had been given for the promise. How did he answer the argument that was put before him that was based on his judgment in High Trees? He said, the doctrine of promissory estoppel cannot found an action, meaning it cannot stand alone, but it would make the modification of a promise enforceable. And that's him simply saying that a gratuitous promise without anything else cannot be used as a cause of action. You cannot sue somebody because they made you a promise and it was gratuitous on the basis of promissory estoppel. Now, the decision of High Trees and Coomb is a great example of the operation and development of the doctrine of consideration. It shows us that there are a lot of problems that can arise when there's a careless suggestion for reform. In Coomb, there were very good reasons for not enforcing the husband's promise, apart from the doctrine of consideration. First of all, enforcement of the husband's promise would permit the wife to avoid the requirement that a contract between a man and his former wife to provide support had to be approved by the court. The wife did not have to rely on the promise if she needed support from her husband. She had the right under divorce legislation to apply for support. Also, Denning had noted that she was earning more than her husband and perhaps unlikely to be awarded any maintenance. Denning's efforts at reform were tested again in D&C Builders and Rees. In the next case, Petrodis, the plaintiff leased restaurant space in a shopping mall from the defendant. The lease expired June 30th, 1981, and it had an option that was exercisable until December 31st, 1980. If the rent was not agreed upon, it was going to be fixed by arbitration. The plaintiff indicated a desire to renew toward the end of 1980. The defendant agreed to negotiate in the new year. The negotiations took place from January 25th, 1981 to May 25th, 1981. The negotiations failed on May 25th, 1981. The defendant ordered the plaintiff to relocate within a month, and the defendant leased the premises to somebody else. And the plaintiff sought a declaration that the option had been exercised. The issue here was, is promissory estoppel an independent cause of action? And here the court says that promissory estoppel is generally understood as a doctrine to give effect to a representation by one party that it will not enforce its legal rights, with the intention that the representation be acted on by the other party. This doctrine can be applied even though there's no detriment to the other party. And promissory estoppel is inapplicable in the absence of an existing contract. So all of these principles we've talked about before. The reason that promissory estoppel is inapplicable in the absence of an existing contract is because there are no rights to which the purported estoppel can apply. Now, here the option agreement constituted the relevant contract. The option had expired December 31st, 1980, so there were no subsisting rights under the contract that were subject to estoppel. However, the plaintiff was entitled to a declaration of a renewed lease under the doctrine of waiver. Here the landlord recognized the continuance of the right of the tenant to renew. The landlord could have insisted upon the expiry of the option upon January 1st, 1981, but that's not what the landlord wanted. He wanted the lease to continue, and he hoped to persuade the tenant to accept the proposed rent. It would be inequitable to permit the landlord to terminate the negotiations without some notice to the tenant. In Oberter, promissory estoppel, they said promissory estoppel can be applied as a sword to establish a claim, but the representation must be at a time when the legal relationship exists. So we can't use it to create a legal relationship between the parties. When you're looking at promissory estoppel, the traditional view is to see it as a shield and not a sword, meaning it may be raised as a defense to an action that is brought on the original contract. That simply means that if somebody sues on a contract and there has been breach of that contract, then the party being sued can raise promissory estoppel as a defense. Yes, I breached the contract, but I did it because the other party led me to believe that I could. So that's what we mean by using it as a shield. Now, we also know that it may not be used to create a contractual right if there is no contract. In Petrodis, the judge wouldn't use promissory estoppel because he said that there was no legal relationship that existed. And in Canada, we can only use the doctrine as a blunt sword. So if we're going to use it as a cause of action, as in we're going to sue somebody on the basis of a promise, and we're going to sue the person who made the promise, that lawsuit must be within the confines of a legal relationship. We cannot sue somebody for making a promise, a gratuitous promise, that we've relied on if there is no legal relationship. And here in Petrodis, the landlord saw that while the lease itself continued after December 31st, 1980, the option did not. And it's the existence of the option that is the legal relationship upon which promissory estoppel must be founded. So the question in Petrodis is, they didn't find a contract, but could estoppel not have arisen prior to the expiration of the option? Could we not say that there's a representation in the defendant's implicit promise to extend the option? If we say that promissory estoppel can only be used defensively, then what is the difference between promissory estoppel and waiver? Not much difference. There, promissory estoppel would simply be an expanded version of waiver. It would appear that traditional waiver would be subsumed within the doctrine of promissory estoppel. So think about waiver and promissory estoppel. In waiver, you waive your rights to something under a contract. Maybe your right to accept certain goods on a certain date, payment on a certain date, something else that arises under the contract. Then you go back and you reassert that right, and the person against whom you're reasserting it uses the doctrine of waiver as a defense. The party who waives strict compliance with the contract may not, at least without giving reasonable notice, insist on punctual and exact performance. Promissory estoppel is that the estoppel that has developed is not based on a factual statement, but on a promise. It is an undertaking as to future conduct. I promise I will do this. Think of high trees. The landlord promised the tenant that the tenant could pay a reduced amount of rent throughout the war. After the war, the landlord came back and wanted the arrears, the difference between what the lease said and what the landlord was actually paid. In Petrodis, the landlord hadn't just waived a right under the contract. He made a new promise. And it was on that new promise that he wanted to go back on. So promissory estoppel arises in response to the landlord going back on the promise and prevents him from doing so. So when we're looking at promissory estoppel, even when it's only used as a defense, it's not exactly the same as waiver. It subsumes waiver, but it's a slightly expanded version of waiver. It can be used, it's a much broader doctrine of waiver if it can be used as a sword. In Roby Show and Case Popular, the plaintiff owed several debts, including judgment to the defendant for over $3,000, and the defendant's manager agreed to participate in debt consolidation by the plaintiff, which meant the plaintiff agreed to pay $1,000 to the manager and the manager agreed to remove the judgment from the registry. The plaintiff sent the check for $1,000 to the defendant, but the defendant did not cash the check, and the defendant subsequently refused to ratify the agreement. And the plaintiff sued to require the defendant to honor the agreement to remove the judgment. Now, in this here, Wadhams has criticized the traditional doctrine of promissory estoppel, which says that it can only be used as a shield. If the reason for enforcement is the promisee's reliance, well, the reliance may be just as strong whether the promisee appears as the plaintiff or as the defendant. Promissory estoppel is available to the plaintiff as a blunt sword, which means the plaintiff is entitled to rely on the doctrine to enforce altered rights, to enforce a promise that was made. Here, the defendant enjoyed strict rights under the judgment. The strict rights were altered by a promissory estoppel, and the plaintiff was granted an order compelling the defendant to adhere to the altered rights. So here you see in Roby Show the use of promissory estoppel as a blunt sword. They already have an existing relationship, but the promise is being sued upon. The promise is not being used as a defense. And the next question is, can promissory estoppel be used as a sharp sword? And we deal with that in the next podcast.